Hello and welcome to LifePlan Legal Arizona's Estate Planning, Elder Law, and Probate Q&A. Today's question is, what happens if I die in Arizona without a will? In Arizona and other states, if you die without a will, it means you have died intestate. The probate court in Arizona oversees and administers the intestacy laws that determine how your property is distributed after your passing. This property includes your bank accounts, your investment accounts, real estate, cars, and other assets that you own at the time of your death. If you own real estate in a different state, such as a vacation home in California, or a condo in Nevada, a second home in Utah, or investment property elsewhere, each property will be handled under the intestacy laws of the state where that property is located. If you own property outside of Arizona, you may want to watch our video on living trusts for ideas on how to make sure that your out-of-state property is handled the same way that your in-state property is handled, and avoid probate in multiple states and multiple jurisdictions. The way the intestacy laws are applied varies depending on whether you're single or married at the time of your passing, or if you have children. Most of the time, your property will be distributed or split between your heirs. This could include your surviving spouse, your children, parents, siblings, aunts, uncles, nieces, nephews, and distant relatives. In cases where no relatives can be found, the entire estate goes to the state. So let's talk about a few scenarios. What happens if you die without a will and you're single and have no children? Your estate will be distributed in the following order. First, to your parents if they're still alive. If your parents predecease you, then your estate will go to your siblings, including half-siblings. If there are no living parents, no siblings, your estate will pass to your grandparents. One half to your paternal and one half to your maternal grandparents, if they're both alive. If you get this far and there are no grandparents, your one half for paternal will go to any descendants of your paternal grandparents, so your aunts and uncles on that side, or your cousins, if there are no aunts and uncles. Similarly, the other half to your maternal aunts, uncles, and cousins. Sound confusing? It can be. And that is why I always suggest you create a will during your life. You take control. You be intentional with how your property will be distributed. Don't leave it to the probate court to identify who gets your property. That example was if you're single with no children. How about if you're married? It is less complicated if your spouse is the parent of all your children. Arizona is one of 9 community property states. If you pass away married, your surviving spouse will get all of your property. The potential complication arises if you have children from a previous relationship. In these cases, the probate court will look at your community property and your separate property differently and distribute accordingly. I go into much more detail on this in another video about dying intestate with children from a prior relationship. The easy answer is, it is much better to just create a simple will and avoid any possibility of intestate distribution. Okay, what about those who are single and have children? In this case, your entire estate generally will go to your children by representation. What does by representation mean? Arizona has a unique approach in dividing intestate assets among children then living and predeceasing children. It might help if we take a look at another example. Let's say you have 4 kids and $40,000 to distribute, and all 4 children are living. Each child gets $10,000. But what if one of your children predeceases you? Yeah, that's not that big of a problem. That child's descendants would split the $10,000 set aside for that child. But what happens if you have 2 children predecease you? The calculation gets a little trickier. The 2 remaining living children would still get their $10,000 each. However, the remaining $20,000 would be split among the next generation. For this example, let's imagine that one child had 2 children and the other child had 1 child. your 3 grandchildren would split the remaining $20,000 into thirds. Yikes. You can see why it is so important to be intentional about your distribution strategy and create a will during your lifetime. Another question you may have is, what happens if I have a domestic partner or if I'm in an unmarried relationship and I die without a will? I address this question specifically in a different video. Also note that some valuable assets won't pass through your will or be affected by Arizona intestacy laws, including property held in a living trust, proceeds from life insurance, retirement account funds, beneficiary deeds, and property owned as joint tenant or with right of survivorship. I hope that you enjoyed this week's Q&A with LifePlan Legal Arizona. Before you go, let me invite you to support our mission of helping 10,000 Arizona families pass their values along with their valuables to the next generation. If you or somebody you love would like to join our growing family of 5-star happy clients, schedule your free strategy session by calling 602-910-4068, 602-910-4068, or head over to lifeplanlegalaz.com for a link to schedule your free strategy session. And don't forget to subscribe.